Welcome to the Law Student Digital Notes, Criminal Law 1, Part 2, a digital note and reviewer of a JD student. This Law Student Digital Note Reviewer is intended only for the review and recall of topics and contents covered in Criminal Law 1. The maker of the video does not claim the ownership of the commentaries used in this reviewer. The rights belong to the respective authors and are properly cited during the making of this digital reviewer. No copyright infringement is intended by the maker of this video. This digital reviewer is made using and by referencing to the book The Revised Penal Code, Criminal Law, Book 1, Articles 1 to 113, written by Professor Luis B. Reyes. The maker of this video strongly recommends to all law students to buy the said reference material as it will augment their continuous desire to study the subject matter in-depth perspective. The part 2 will cover the retroactive application of law, the constitutional rights of the accused, the statutory rights of the accused, and the rights of the accused which may be waived. The second limitation requires that criminal laws must be of general application and must clearly define the acts and omissions punished as crimes. To give a law retroactive application to the prejudice of the accused is to make an ex post facto law. According to the case People versus Villarasa, 81 SCRA 9597, the court ruled that the penalty of prisión mayor medium or 8 years and 1 day to 10 years imposed by Presidential Decree number 818 applies only to swindling by means of issuing bouncing checks committed on or after October 22, 1985. That increased penalty does not apply to staffa committed on October 16, 1974 because it would make the decree an ex post facto law. Its retroactive application is prohibited by Articles 21 and 22 of the Revised Penal Code and Section 12 of Article 4, now Section 22, Article 3 of the 1987 Constitution. Article 3 Bill of Rights of the 1987 Constitution provides for the following rights. 1. All persons shall have the right to a speedy disposition of their cases before all judicial, quasi-judicial, or administrative bodies. 2. No person shall be held to answer for a criminal offense without due process of law. 3. All persons, except those charged with offenses punishable by reclusion perpetua, when evidence of guilt is strong, shall before conviction be bailable by sufficient sureties or be released on recognizance as may be provided by law. The right to bail shall not be impaired even when the privilege of the writ of habeas corpus is suspended. Excessive bail shall not be required. 4. In all criminal prosecutions, the accused shall be presumed innocent until the contrary is proved, and shall enjoy the right to be heard by himself and counsel, to be informed of the nature and cause of the accusation against him, to have speedy, impartial, and public trial, to meet the witnesses face to face, and to have compulsory process to secure the attendance of witnesses and the production of evidence in his behalf. However, after arraignment, trial may proceed notwithstanding the absence of the accused provided that he has been duly notified and his failure to appear is unjustifiable. 5. No person shall be compelled to be a witness against himself. Any person under investigation for the commission of an offense shall have the right to be informed of his right to remain silent and to have competent and independent counsel, preferably his own choice. If the person cannot afford the services of counsel, he must be provided with one. These rights cannot be waived except in writing and in the presence of the counsel. No torture, force, violence, threat, intimidation, or any other means which vitiate the free will shall be used against him. Secret detention places, solitary, incommunicado, or other similar forms of detention are prohibited. Any confession or admission obtained in violation of this or Section 17 hereof shall be inadmissible in evidence against him. 6. Excessive fines shall not be imposed, nor cruel, degrading, or inhuman punishment inflicted. 7. No person shall be twice put in jeopardy of punishment for the same offense. If an act is punishable by a law, and an ordinance, conviction, or acquittal under either shall constitute a bar to another prosecution for the same act. 8. Free access to the courts and quasi-judicial bodies and adequate legal assistance shall not be denied to any person by reason of poverty. The following are the statutory rights of the accused according to Section 1, Rule 115 of the Revised Rules on Criminal Procedure. 1. To be presumed innocent until the contrary is proved beyond reasonable doubt. 2. To be informed of the nature and cause of the accusation against him. 3. To be present and defend in person and by counsel at every stage of the proceedings from arraignment to promulgation of the judgment. 4. To testify as a witness in his own behalf but subject to cross-examination on matters covered by direct examination. His silence shall not in any manner prejudice him. 5. To be exempt from being compelled to be a witness against himself. 6. To confront and cross-examine the witnesses against him at the trial. 7. To have compulsory process issued to secure the attendance of witnesses and production of other evidence in his behalf. 8. To have a speedy, impartial, and public trial. 9. To appeal in all cases allowed and in the manner prescribed by law. Rights of the accused which may be waived and rights which may not be waived. A right which may be waived is the right of the accused to confrontation and cross-examination. A right which may not be waived is the right of the accused to be informed of the nature and cause of the accusation against him. The reason or principle underlying the difference between rights which may be waived and rights which may not be waived is that those rights which may be waived are personal, while those rights which may not be waived involve public interest which may be affected. This ends the part 2 of this digital reviewer. To become updated with new uploads, please click the subscribe button and notification bell. See you again in our next reviewer.